Welcome back, California. It's 35 minutes past 2 p.m. and you're dialed into Ledger on the Law. The telephone number to be part of our conversation, 800-222-KABC. Again, the number to join us live on air, 800-222-5222. We've carried over Stephen R. Golden and his right-hand man, Tom Carozzo. They are lawyers, or Stephen's a lawyer, and Tom is the intake specialist at the firm. They are here to talk about you losing your home, or hopefully them saving your home. I know, Stephen, you were at the 2nd District Court of Appeals this last Wednesday, which is a federal court, no small deal. Tell us about it.
Okay, I was sitting in court Wednesday, and I'm arguing that the new homeowners Bill of Rights that was enacted in January ought to apply to the facts of this case, this foreclosure defense case, and these actions took place a couple of years ago. And the judge looks at me, and one of the judges who was definitely not on our side, he says to me, Mr. Golden, you're not arguing, are you, that somehow the banks ought to change some actions that they took, a year ago or 2 years ago, and change some of their things that they've done? And in my own quiet, gentle, inevitable way, I says, yes, I do. Let's step back, Your Honor, and Your Justice, and think about this. A year or two ago, they got caught doing a lot of robo-signing, signing false documents, notice of defaults with bogus information, just signing them, having people not look at the information to verify that they own the loan, that the homeowner is in so much in default. They just signed them and filed them, which starts the private foreclosure process. And I said, they got caught with these crimes. Then they agreed to a settlement with the 50 attorney generals not to do these type of practices anymore. And so in California, we rolled that into legislation that was approved last summer, and that became effective January 1st. Look, the banks got caught doing these things, and the California legislature seems to believe there's a foreclosure process. The courts ought to be stopping some of these bogus foreclosures. The judge says, Mr. Golden, look, I'm right here. He says, you don't have to speak so loud. The moderating judge says, Mr. Golden, just turn the mic away to the other side, So,
they de-mic'd you.
Yes.
We might have to do that on this show once in a while.
I was going to say
I'm very much controlled when I'm here. The bailiff was looking at me. I thought, I've been in court. I think
they were going to cuff you out.
Am I going to cuff him and take him out? Look, someone's got to speak to power. You've got to have a sense of injustice that what the bank has done, if they've done some fraudulent activity, someone's got to speak up.
Well, and that's the kind of attorney I want. If I'm in crisis mode and I'm going to lose my house, I want somebody who's going to start screaming at the banks and screaming at the courts and screaming at everybody.
I would say even if they throw him in jail, it's okay.
Absolutely, that's fine with me.
We do justice there by putting me in a jail.
800-222-5222, 800-222-KABC. If you would like Stephen R. Golden to scream at you on air, you can do that right now. Let's talk to his softer side. Right. Tom, why don't you jump in here? What's your current state at the firm?
Well, I don't know. I mean, it's kind of shaky. I noticed I went in there today and one of the desks was gone from the office.
You're next.
That may be an early sign of, temporary, unemployment.
You do a lot of intake, though, right?
Well,
you have offices around the state. You told me during the break you'll take cases statewide, and you oftentimes, at Stephen's direction, will go up to Oxnard and speak to clients about their issues, and then put them in touch with Stephen if the case warrants it.
Well, absolutely. I'm one of the first people that the client would see when they come in, and we do an assessment. We try to find out what the status of their case is, and we do kind of a legal triage. We determine, how critical of a patient are they? Are they about to go into foreclosure? Have they just started the process? And then I explain the entire process to them so that they're aware of what's going to happen, when it's going to happen, what the timeline is going to look like, and what the possible outcome might be. And of course, we don't guarantee anything, but we have been very successful in helping many, many clients.
I heard that if they can't find the note itself, that's definitely grounds for a delay in the foreclosure. And in some states, I've learned that if they can't find the note, the whole loan may be extinguished. Is that right?
Exactly, and some others. The new law in California will probably speak to this. There'll be some, I believe, a court of appeals decisions in the next few months or a year that might discuss that. In other states, yes, they separated the note from the deed of trust. They don't show them a sign into the bank that's foreclosing. The court said, don't come in here. You don't have it. You cannot foreclose. And yes, you do. In California, you don't have to produce the original note. But under the Uniform Commercial Code, when you don't have the original note, you got to explain what happened to it. And now in California, you can't just say, well, it's lost somewhere. You got to put under clear, concise evidence, explain in detail what happened to it. And in some of these instances, you think I'm crazy. The banks don't know what happened to the original note. So that is a problem. And again, all the duties are on the banks to prove that they have the standing, that they have the assignments of the note and the deed of trust to whoever it is they're working on behalf, whoever the investors are on the loan. Believe me, it is a problem, and it has been a problem in other states, and I think it's going to come to light in the press in the next few months in California. We'll see.
What happens when you get up to, or somebody gets up to like a week before foreclosure and then they contact you? Can you still kind of jump in and stop it?
It is, but it's like a train going down the station. Yes, you can go into court. That's what the new law allows for. You can go into court a day before the sale and get a court order stopping the sale on various grounds. They didn't do their due diligence. They didn't contact you and try to work out a loan modification. There's a bunch of intricate rules that they have to perform, and if they don't get them right, the law provides you can get an attorney. They can take him to court, and they have to reimburse you for the attorney's fees you expended going in and stopping the sale. So don't forget, the bank has to pay their attorney, they have to pay your attorney, and they may have to face damages. So the incentive is there. But if you don't have an attorney, you're not going to get much results.
Something I don't understand is why don't banks want to give loan modifications? Won't they lose more money if there's a foreclosure?
Well, the reality is they don't own the loans. They operate on OPM, other people's money. The banks just service the loans. And don't forget, when you are late on your payments, they get 4 times the amount of service fees they would if you were current. So there's a
What?
It's crazy. It's a crazy system. So if they want you to be in default. They actually want you to be, and when they foreclose, they're going to get all that money off the top, and the investors who actually own the loan, the 401k owners, people who are retirees who invested into this, they're going to lose out. Now, on the other side of the coin, the pooling and service agreement between the lenders and the trust where your loan was placed and sold to investors around the world, there's a provision in most of these that says that if they do lower the payment, they have to reimburse the trust, the difference between the monthly payment that you have and the current payment and the payment that you're seeking. So they're not going to do that. There's a disincentive to work with you, and there's an incentive to foreclose. Nobody explains that. No one out there is saying this. The government's not saying this. The Obama administration's not saying this. Their HAMP program was it's just a PR mess.
So these trusts that you're talking about, these are people, private investors who are investing in real estate trusts?
No, here's how it works. The Wall Street firms went to the managers of pension funds, said, "Hey, we got a way to make money, turn your profit here." They took their money, had warehouse loans sent to the big institutional lenders, Chase, B of A, and that was not their money. It was the money that they got from pension holders that went and funded these loans. The loan documents went into the pool, into the trust, and they spliced and diced it, sold bonds based upon a piece of the aggregate loans in that pool. And it's a big Ponzi scheme, and that's why Eric Holder won't prosecute the banks, because it's really an awful, ugly situation.
Wow.
So what are the first steps? If one of our listeners has this issue, presumably they call your office, and then what are you going to ask them to do? Is this an easy process, or is it overwhelming?
Tom can talk about the paperwork aspect that gets started.
Yeah, it's not overwhelming. It is to them when they don't know what's going to happen, but we lay out very carefully the steps that they need to take. When they come in, we find out at what level they want to retain us. Then we send out some letters to the bank. So we begin working with the bank right away, and they don't have to deal with the bank anymore. They deal with the bank through us, and that relieves them of a great burden right off the top.
And so do they retain you on a contingency fee basis?
They retain us on a monthly fee, so they will pay us a monthly fee to negotiate and litigate at the same time. Typically, that's way below their monthly payment, and that's how we work. We set it up to anybody can afford us.
That's great, and that's a big concern. I mean, people that are in financial trouble don't have money oftentimes to hire an attorney, but what I'm hearing is they may actually save money by hiring you in month one.
Exactly, because we keep them in the home, we negotiate for them, and we often can get not only a fixed low interest rate at market level, sometimes 2%, but often we can get their principal reduced for them. But also, don't forget, there's significant damage provisions under the law. If, in fact, they actually foreclose against you, it might be the best thing that ever happened to you, because you can get 4 times the economic damages. If you got any equity, say you had $100,000, that's $400,000 equity. If, in fact, they foreclose wrongfully, folks, that is a significant hit on your credit rating. And you multiply that, get a forensic expert in there, talk about the damages that you would incur paying a higher interest rate for 20, 30 years. We're talking serious bucks.
So wait, will you represent people who have been foreclosed on already?
If they've been foreclosed on since January 1st, I think I will definitely take those cases.
Okay.
Stephen R. Golden, Tom Carozzo, thank you once again for coming in. If you would like to speak to them, 626-584-7800. The number again, 626-584-7800. They'll offer you a free consultation, so there's no obligation if you contact the office, and they'll let you know if they're the right guys for you. As you can see and as you've heard on the air, they're straight shooters, and they tell it like it is, and sometimes with a lot of passion. So once again, thank you, gentlemen, for coming in, and we'll be right back, Phil, after a very short break.
Thank you.
Now more useful than ever.